Now I will welcome our Dr. Ashok Nataraj, LLB, who happened to be a veterinary surgeon also. So now he will give some pearls regarding legal practice, because I think all of us have encountered legal notices and we fight because we are not gods. We have our own bad results. So we will listen to Dr. Ashok Nataraj regarding some legal pearls in retina practice.
Thank you, Dr. Mahesh, for giving me this opportunity, and thank you, Drishti KSOS. Now, at the outset, the background for this discussion regarding legal pearls has already been said, because you know retina practice and outcomes after retina surgery is not absolute, and nobody sees the retina. See, you can show the cornea, you can show the lens, but you cannot show the retina. So when you talk about retina, it's like blind men talking about the elephant. Each person will imagine about retina in different ways, and finally what idea they have about the disease, nobody knows. So the first pearl I would like to say is the most important thing is avoid casual comments. And this happens when you're a doctor and you're a relative of the patient. So one patient will come and ask you, sir, I underwent retinal detachment surgery with the other doctor. Now I'm not seeing well. Then you say, see, that doctor has not put belt buckle. That is why retina has detached. I am all my cases, there is no problem, but that of doctor I know, because you are trying to show this one-upmanship, saying that you are better than the other. See, I agree, that's a very, very natural human tendency. And 90% of the litigations in retina practice comes because one of your colleague or some unsuspecting person has passed an adverse comment about you with the patient. Because when the patient comes for litigation or with a complaint to you, he will say the nuances. Sir, that infranasal brake you have not lasered. That is why retina has read it. Now, how will they know that infranasal brake has not been lasered? Because one of us has only done that. So, you should always resist this temptation of one-upmanship and trying to say that, trying to show that you are better than. You have hundreds of healthy ways of showing others that you are better than the others. I think we should all avoid doing this. That is the most important thing. Now, this is one scenario where this is an actual scenario, a case of post-op endophthalmitis. It was a cluster endoff. So it was treated, it was referred to the retina surgeon. He also treated. Some patient recovered initially. Then the eye went for evisceration. So this patient was sent for a second opinion to a higher center. Now, one of the PGs there in the higher center says that, see, you've come a little bit late. If you had come earlier, we could have done something. So that is enough, no? See, just that small comment is enough, because when you're saying you don't know the background, what exactly has gone through, what exactly other person has, because you're also a surgeon, no? So this patient, what he did, he said, okay, I should have gone there earlier, this surgeon. And he not only involved the cataract surgeon, he said the retina surgeon also is not good, because that poor retina surgeon was only trying to help. He is also not good, so the complaint went against both the cataract surgeon and retina surgeon for deficiency of service. So the most important thing is, please don't show your one-upmanship in all these things. Be patient. Try to understand what is the situation before you pass any casual or adverse comment, especially when the patient is your close relative. So that is the most important thing. Second thing is taking an appropriate consent. So this is something which has been really underplayed in our system, because consent is taken for granted. Unfortunately, many of the patients, when they file a consumer protection case, they don't talk about consent. So if they had looked at the consent, they know that for that particular surgery a proper consent was not taken, and not taking a proper consent is itself a crime, because it violates patient's privacy. So this is one incident that happened to me. This was a 75-year-old gentleman. He had a chronic retinal detachment. He was one-eyed. And patient consent was taken. I asked, is consent taken, everything okay? Then I had a doubt. I called the patient. I said, it's a one-eyed patient. I should take a video consent. So I started asking, what is your name? He barely told his name. Then I asked him, where you come from? I come from Trivandrum. Okay. What is your age? He said he is 20 years old. Then I realized that something was missing. So finally, when I started talking to him, actually this patient is suffering from dementia. So suppose you had taken the consent, written consent, and something happened, went for a case. See, the patient does not have the capacity to give valid consent, no? Because he is having dementia. So these are all small things. So in that situation, you should call the next of kin, sons, daughters, etc., and take a proper consent. So this consent taking, you should not take it for granted. And whatever eventualities, possibilities that can happen in that particular case, you should involve in the consent. Now, this is one important thing. Another scenario, a child suspected of retinoblastoma is got into the, for examination under anesthesia. Suddenly you find that the retinoblastoma is very severe and the eye has to be enucleated. Now you have this paternal attitude. You take over the role of the parent and God for that patient and you immediately enucleate. And you come out victorious saying that because I have managed your case, you did not require another surgery, I have enucleated the eye. Now the parents ask you, who gave you consent to enucleate the eye? You understand? So these kind of things should be avoided. Now, our post-cataract surgery end off. Now, okay, you did surgery, now IOL has to be removed, then only the end off will go. Now you remove the IOL and patient says, sir, I paid 10,000, 50,000 rupees for the IOL. You have removed the IOL without my asking. Only if, sir, you know, whenever, only if you put IOL, you will see, no? Yeah, yes, correct. Now you have removed the IOL, how will I see? So what will you answer the patient? So all these small things, no, you should take a proper consent before, because if you don't take a valid consent and do something out of this godly or paternal attitude, things are going to be very bad. So these are the different types of consent, and in India, what we follow is the prudent doctor test, in the sense that doctor has some authority to take a proper consent from the patient, and you have to inform reasonable things to the patient before you take a consent. So another important thing is, patient says, I don't want treatment. So in that situation, like if a patient comes with PDR and patient says, I don't want any treatment for PDR. 6 months later, patient comes back with a blind eye. Now the relatives are, doctor, what did you do? You should have given treatment. No, he didn't consent. So in that situation, it is your duty to prove that patient did not give consent. So you document it there. Patient is not willing for treatment. And Pearl 3 is proper documentation and accepted protocol. So this is our famous ROP case. The only mistake they did was it was not documented there. There was the patient had to go for an ROP screening. The pediatrician did not document in the case sheet. Because of that, this case went against the doctor, and doctor had to pay a enormous compensation. Again, this is a post-endophthalmitis case that happened in Jipmer. What happened was they did not record the protocols. So what it was found was pre-op, povidone iodine was not instilled in the eye. On the day of when the patient came with intravitreal injections were not given. Probably these are all done, but these were not documented. And all these things went against the doctor and they had to pay a compensation. So 3 things: avoid casual comments. Second, take a proper consent. Third thing is always follow proper documentation and follow accepted protocols. So in law, we say law supports only the vigilant. Law doesn't support lazy people, careless people. So it is your duty to be vigilant and not be dormant and come out with flying colors in your career. Thank you very much.
Thank you, Ashok. Very good talk. And we have sessions on medical law in the afternoon also. This needs lot of discussion.